Is it noon?
It is 11:59.
Okay. Tell me when it's noon and I'll start.
Okay.
Good afternoon. We are going to get started on our very unusual St. Patrick's Day CLE today. Our speaker is here with us in the MJC, and he will be presenting to two of us in person, and then all of the rest of you that are out on the webinar. So thank you for joining us online. Marshall Tannick is our speaker today. He is a shareholder with Meyer, Noose and Tannick. For 35 years, he's represented clients in a wide variety of legal matters. He is certified as a civil trial specialist by the MSBA, and you are probably well aware that he is a frequent speaker and author on a variety of interesting legal topics. So I will turn it over to Mr. Tannick.
Thank you very much, Liz. Appreciate the opportunity to be here and appreciate the opportunity to speak to this webinar. A number of years ago, I gave a presentation on a legal topic at the University of Minnesota, and I went to the wrong building on campus, and they had scheduled it.
The audio is out.
No shit.
Oh, how about this one? Okay.
Should I start over again, or?
Yeah, let's go back to maybe a minute ago.
Well, thank you very much for coming to participate this afternoon in this webinar. I'm Marshall Tannick. I'm pleased to be able to give this presentation. St. Patrick's Day is a day of gaiety, but there's not much gaiety in our lives these days, or in the state, or in the world for that matter. But perhaps we can spend a little bit of time focusing on things that are a little bit interesting and a little bit informative and entertaining as well. We have lots of time today for not only this presentation, but for other things to do, because none of us are going to any St. Patrick's Day parades today, and none of us are going out bar hopping tonight. I guess we can just focus on the law and lore of St. Patrick's Day. As some of you know from attending some of the other presentations I've made, what I try to do in these presentations is take a theme, and today's theme is St. Patrick's Day, and focus on interesting, important, and sometimes just offbeat legal cases in Minnesota, largely, that have shaped the law, that have shaped the law and the theme of St. Patrick's Day, but also how how St. Patrick's Day and some of the cases that spring from St. Patrick's Day have shaped the development of the law. So I think you'll see themes in this discussion that run beyond just St. Patrick's Day and affect other areas of the law. So, as soon as, does that move? Nope. Yeah. Oh, sorry. Am I clicking here? Yes, I'm not. All right. Hold on, folks. Here we go. So these are some of the areas we're going to cover, and let's get into them. Probably the quintessential St. Patrick's Day case is not a Minnesota case, but it does have Minnesota roots to it. The case is Hurley versus Irish GLD Group of Boston, and it was the Boston St. Patrick's Day Parade case. In that case, the organization that sponsors the annual St. Patrick's Day Parade in Boston, which goes back to the pre-revolutionary days, I think it goes back to the early 1770s, fast forward to the mid-1990s, the organization precluded a gay lesbian group from participating in the parade. That parade, like most parades, have all kinds of different people marching in it in schools and bands and organizations and clubs of all kinds. You apply for it, and generally, if there's enough room and space, you're allowed to participate in the parade, maybe not every year, but every other year, depending upon space and commitments of organizations. However, the Boston folks, and this is a private organization that sponsors the parade. Although it was private, it obviously has a great deal of public input to it because the streets are set aside for the parade. There's a law enforcement that's assigned to the parade, but nevertheless, it's a privately sponsored parade. They refused or denied the application of the gay group to march in the parade. That case reached the United States Supreme Court. The organization, the gay organization, made a claim under the Massachusetts human rights law, which is comparable to our Minnesota human rights law, maintaining that they were discriminated against on the basis of their sexual orientation. At that time, Massachusetts was one of the few states back then that had affectional preference protection for gays and lesbians, as did Minnesota. Minnesota was one of the first states, perhaps the first state to do so in the early 1990s. Massachusetts also had such a law. So the parade aspirants sought a determination that they were the victims of unlawful discrimination under the state anti-discrimination law. The organization based its defense on the First Amendment, and their defense essentially was, we don't want to give out a message that is supportive of gay rights. And this is 25 years ago, but that was their position. We are against gay rights. We don't support gay rights. And if you force us to allow gay marchers in the parade carrying banners and rainbow insignia, that would be antithetical to our own views of what we think is proper social and moral conduct. The Supreme Court ruled in favor of the parade organizers. The court held unanimously, I might add, that the parade organizers had a First Amendment right to preclude the gay group from marching in the parade. Query what that result might be today, but back in the mid-90s, the court unanimously ruled that the organization cannot be forced under the First Amendment to allow the gays to march in the parade because it's a form of compelled speech. And the state is not entitled to force a private organization to convey a message that's antithetical to their own beliefs. Fast forward about 5 more years and we get to the Boy Scout case. The Boy Scout case was again before the Supreme Court, involved the issue of whether the Boy Scouts may prohibit, discriminate against gay scout leaders. The Boy Scouts refused to allow gays to be scout leaders or troop masters, I think the term was. That case reaches the Supreme Court in 2000, and it really is predicated in large part, the arguments on both sides turn on the parade case, the Hurley case. The court this time does rule in favor of the Boy Scouts and holds that the Boy Scouts may, under the law, under the First Amendment, preclude gay scoutmasters. Again, the claim came through the state court system. There was, as you know, no and is not any federal protection at the present time for gay rights, but there was state protection in New Jersey, where I think the case arose out of. And the court, again, kind of reasoning along the lines of the Hurley parade case, said that as a matter of law, the Boy Scouts are not required to allow gay scoutmasters. The case turned on First Amendment, but a different prong of the First Amendment. The Hurley parade case turned on the compelled speech doctrine, that private parties should not be forced to convey a message that they disagree with, that it disagrees with. The Boy Scout case had the same result, although a much narrower vote, 5-4, but the Boy Scout case turned on the First Amendment prong of freedom of association. And the court held that the Boy Scouts have a right under the First Amendment to define who they want to associate with. And if the Boy Scouts feel that it is inappropriate to have gay scout masters because it conflicts with the Boy Scouts moral code, then as a matter of First Amendment freedom of association, in a narrow 5-4 decision, the court upheld the Boy Scouts position. Again, one would wonder what that ruling might look like today. Could be the same, could be different, but in those two cases, the First Amendment concerns overrode the claims of the affectional preference claims of discrimination. What's the relationship to Minnesota? Well, both of those cases have a bit of a Minnesota heritage. They go back to the mid-80s case of Roberts versus USJCs. That's a Minnesota case that came through our court system. In the JC's case, the national JCs, a very well-known and still existing service organization, private service organization, community civic organization, had a rule that disallowed women from participating in the JCs. The JCs are, I'm not sure they're quite as prominent now, but back in the day, they were like the Rotary and like the Exchange Club and the Kiwanis Club and the Lions Club. They were a civic organization of people who joined and went to events and lunches and networking and did some social outreach and did some charitable work and the like. But their national rules barred women from participating. There was a ladies auxiliary of the JCs, but the main body of the JCs barred women under one of their bylaws that went back many, many years. The two Twin Cities organizations that were essentially affiliates, franchises, if you will, but they were affiliated with the national organization. Both the Minneapolis and St. Paul affiliates broke from that and allowed women to participate. The national then wanted to disaffiliate from the local and essentially said, you're violating our rules. You can't have women in the organization, so we're going to take away your franchise rights, your affiliation rights. So that was the nature of the clash there. The Minneapolis and St. Paul organization wanted to allow women. The national would not allow them to have women. The Minnesota Human Rights Commission became involved in that insofar as it ruled that barring women from participating in the JCs constituted a violation of the gender discrimination provision of the Minnesota Human Rights Act. So that case then reached the United States Supreme Court, much in the same context as the later Boy Scouts and St. Patrick's Day Parade. State court, the issue being whether the state prohibition against discrimination, in this case gender discrimination, requires an organization to, or prohibits an organization from discriminating, or whether a private organization can set its own ground rules, even though those ground rules are discriminatory under state law. The JCs, the national JCs, defended their position as an association claim, freedom of association, which worked some years later in the Boy Scout case, but it didn't work in this case. The Supreme Court in the Roberts case, the Minnesota case, held that the JC's prohibition of women members was not defensible under the First Amendment right of association. And the court reasoned that the JCs are not an organization that necessarily has a moral code or moral convictions. They didn't say it was immoral, but they said, unlike some other organizations, the JCs are basically a private organization that encourages people to join. And it's important for people to join, business people and people in the community, because they do networking. It's an important way to promote yourself locally and nationally. And it doesn't have any kind of religious connotation to it. It doesn't really have any kind of moral connotation to it. It's just a social club that doesn't give out any messages of any kind other than allowing people to group together. And one of the more convincing arguments, I think, that was made in that case was that the barring women from participating in an organization like the JCs and other organizations like that really limits their ability to network, to advance, for their job mobility and career mobility. And one of the pieces of evidence that was introduced in the case was that many here in the Twin Cities, because the case arose here in the Twin Cities, many of the large companies, the organizations, the banks, the big companies, the big corporations, were encouraging and wanted their women employees, especially management employees and executive employees, to join the JCs and other clubs because it's good. It's good for the organization. It's a way to promote the organization. It's a good networking feature. And if women couldn't participate in that, it would stunt and stultify their careers in the private sector. And that argument was very effective, I think, in resulting in the ruling in the JC's case that the gender discrimination was illegal. Again, that decision somewhat was diluted by the subsequent cases, including the Irish parade, St. Patrick's Day parade case. But those are the triumvirate of cases that stem from the JC's case here in Minnesota. And as a result of the JC's case here in Minnesota, basically the barriers for women participating in many different social and civic organizations have fallen. Back in those days, the 70s and even into the early 80s, many of these organizations, like the Rotary, the Kiwanis, and the Lions, did have prohibited women from joining, and they don't anymore. Society has changed. It's a different time period. But it was a case like the Roberts case that helped break down those barriers to women participation in social and civic organizations. Let's take a look at a couple of more, a few other Minnesota cases that deal directly with St. Patrick's Day. These are also, one of these cases is also an affectional preference case, no less. 1985 case, Blanding versus Sports and Health Club, Inc. It's a Minnesota case, went to the Minnesota Court of Appeals, and it happened right here in St. Paul. Okay? The case arose at a fitness facility, a workout exercise gymnasium facility, exercise facility in downtown St. Paul. One of the members there, a man there, on St. Patrick's Day was seen dancing what the court referred to as an Irish jig with another man. This was on St. Patrick's Day. The man was gay, and he and another man who apparently was gay, the record doesn't make that clear, but the protagonist here did a little Irish jig, dancing a few steps with another man in commemoration or celebration of St. Patrick's Day. He was then ejected from the facility. The health club said, you can't be here. We're going to throw you out of the facility because you engaged in this act that we think was improper. The man brought a claim under the St. Paul Civil Rights Ordinance. This is in the early 1980s. This preceded the enactment in Minnesota in the Human Rights Act of the affectional preference provision. Minnesota did not recognize affectional preference until 1991. The federal law hasn't recognized it yet at all, although there's 3 pending Supreme Court cases this term that may affect that. United States Supreme Court cases. But St. Paul had its own affectional preference provision in its city ordinance, and that was the basis for the lawsuit. The court ruled in favor of the man who was ejected from the because of his St. Patrick's jig. The court said that the St. Paul affectional preference law, which was the precursor of the State Human Rights Act, barred the health club facility from throwing this man out because he engaged in this bit of frivolity with another man on St. Patrick's Day. The court described it as a, quote, impulsive 4 or 5 step dance that was, quote, not offensive to the community at large. In and of itself, it's kind of a small case, but it's the predecessor and precursor in the Minnesota Human Rights Act. I'm not saying there's a direct relationship between the two, but it helps set the groundwork for other court decisions, recognizing that certain action taken by public accommodations against people because of their affectional preference was improper under local laws, and ultimately the state passed the State Human Rights Act, which codified affectional preference in Minnesota as being prohibited and led to a number of other states adopting similar laws. Needless to say, St. Patrick's Day is notable in the law for automobile accidents. Why so? Well, Not too hard to figure that one out, and these cases evince that. One interesting case, an insurance case, St. Paul Mercury Indemnity Company versus Knopf. This was a Minnesota Supreme Court case in 1958. The issue in the case was whether a taxi cab owner's insurance covered him for an accident he was in while he was gratuitously transporting a friend of his and his wife to a St. Patrick's Day party. So the claimant, the individual involved in the case, owned a taxi cab. He drove a taxi cab, and he had taxi cab insurance, liability insurance for his taxi cab. On this particular occasion, he was not driving the cab for commercial purposes. He was merely doing a friend a favor by taking him and his wife to a St. Patrick's Day party, not charging him. So he wasn't operating as a taxi cab, but he was operating as a vehicle. He got in an accident, and the question was, does his commercial vehicle liability policy apply to a non-commercial transportation using the same vehicle on St. Patrick's Day? The court held it did. The Minnesota Supreme Court upheld the applicability of the commercial insurance to the taxi cab driver, even though he wasn't driving as a taxi cab, but just doing a favor for a friend. The court said this was just an isolated incident. The reason a little bit like the sports and health club case, it was just impulsive. It was just isolated. The court kind of used that same reasoning, different case, of course, but the court said this was just an isolated incident. The taxi driver was not using his vehicle for non-commercial purposes on a widespread basis. He just did this on this one occasion, and because he did that on one occasion, it does not preclude his commercial vehicle coverage because he was just, quote, rendering a service to an Irishman to take him to a St. Patrick's Day event, party. So I guess the defense there, or the legal doctrine, is you cut a little bit more slack to an Irishman. I don't know what would have been the case if the person wasn't Irish. I don't know why that, I'm not sure why that was a factor, but the court did note, well, this is an Irishman, and the court noted, hey, this is St. Patrick's Day. We make some exceptions for St. Patrick's Day. So essentially what the court did there is write a couple of exceptions into the insurance policy. I'm sure the insurance company wasn't too happy about the court said, you get an exception here if you're an Irishman and you're going to a party on St. Patrick's Day. And that's a point of law in Minnesota. Another vehicle-related St. Patrick's case, State versus Miller. This is a DUI conviction that occurred again in St. Paul after a man was stopped for DUI late at night on St. Patrick's Day. After, I don't know if the bars are closed, but it was late at night, wee hours of the morning on St. Patrick's Day. Actually, it wasn't St. Patrick's Day, it was March 18th, the night of after St. Patrick's Day. Stopped for a DUI, and at that time, and the law's changed a little bit since then, but at that time, under the Prideaux Doctrine, which had been established by our courts in the 1970s, a person who stopped for a DUI has the right to call an attorney. And the reason that you want to have the right to call an attorney is because in order to at least give some legal advice as to whether you should take a sobriety test or not. I'm not a DUI attorney and I don't know all the ins and outs of that, but basically, if as a general rule, if you don't, if not general, as a matter of law, if you don't take the test, you stand to have your license revoked for a certain time period. However, so it would seem at first blush that you would probably want to take the test, not to have your license revoked. On the other hand, you're kind of sloshed at the time and probably are going to register on the test. You may not want to take the test because it could obviously be strong evidence for a DUI conviction, and also if there's an accident involved, the driver generally would be well advised not to take the test, and which could be a predicate for a liability determination. So there's some reasons pro and con whether you should take the test or not. And the law at that time allowed the driver to call an attorney to get advice. Right? Now it's kind of questionable how effective that was or even is today. The driver has given a 15-minute time period to call an attorney. Most of the time, this is late at night or in the wee hours of the morning. The driver may not have an attorney, may not know an attorney. And even if he does, what's he supposed to do? Call his attorney up and ask her in the middle of the night, what should I do at 2 o'clock in the morning? Should I take a test or not? Well, the attorney might not be real appreciative of getting a call like that and might have to ask a lot of facts and ask a lot of questions to gather the facts. It's a pretty difficult way to advise a client of what to do. On the other hand, if the person doesn't know a lawyer, they have to pick some name out of a phone book. Some of you remember phone books, they used to exist. And they have to pick a name on someone and just call them in the middle of the night. And yeah, back in the day, I got a few calls at 2 in the morning from people I didn't know who apparently picked my name out of a phone book and started asking me questions about whether they should take a sobriety test or not. I didn't know what to do. But it's a pretty ineffectual way to get legal advice. But at that time, that's what the law provided. So now here we are in the St. Patrick's Day case here, the State versus Miller. And the driver was convicted of DUI. He challenged that conviction on the basis that he wasn't able to reach an attorney in order to give advice as to whether he should or should not have taken the sobriety test, which he did take. But he said, if I would have gotten legal advice, I may not have taken the test and the outcome may have been different. At a minimum, my conviction ought to be reversed and I ought to have a new trial, or better yet, the conviction ought to be reversed because my right to an attorney, Sixth Amendment right, my right to at least consult with an attorney was obviated because I couldn't reach an attorney. The court rejected that argument. The court said, no, you could have reached an attorney. You had some time to reach an attorney. You had 15 minutes to reach an attorney, and the court pointed out that on St. Patrick's Day, a number of local attorneys had formed, and I think they did this for many years. I don't know if it still exists now, but back in the day, a number of lawyers would form what was called the St. Patty's Day Strike Force. It's a rather ominous name. What it means is that a number of attorneys, primarily those who do DUI work, would have their names available for people to call them on St. Patrick's Day only, one day only deal. And they would be make sure that they were available, unless they were in a bar themselves, I don't know. But at least the theory was, well, you have this list of names of lawyers who have said that they'll volunteer to take calls from people on St. Patrick's Day only in order to give some kind of legal advice as to whether a driver should or should not take the test, and the driver may ultimately hire them for his legal counsel as well. But the St. Patrick's Day force was in existence back then, and the court pointed that out and said, local lawyers have formed the St. Patrick's Day Strike Force. There's a list of them. You were given that list. You could have called someone on that list. You didn't. That's enough to vindicate your right to counsel. Conviction upheld for the St. Patrick's Day DUI. More car cases on St. Patrick's Day. How much time do we have here? We could go all day with St. Patrick's Day automobile cases. Now, there's just a couple more here that are somewhat interesting. This is a St. Patrick's Day case out of Austin, Minnesota. Man leaves a bar on St. Patrick's Day. A bartender gave a tip to the police and to the Austin police officer, said, hey, you ought to watch this guy. He had a lot of drinks here, and he might not be the best person to have on the road. So the officer then arrests or stops the driver who left the bar and was driving on that road in Austin, and he stopped him on the basis of the tip from the bartender. The man was convicted of DUI and challenged that conviction based on the insufficiency of the information given to the police officer. In other words, it was a Fourth Amendment challenge whether there was reasonable grounds to stop the driver based upon the tip from the bartender on St. Patrick's Day night. And the court said it upheld the conviction. It said that the bartender had given sufficient reasonable articulate reason for for stopping the driver, and the police officer had noticed that the driver had been changing lanes without signaling. Given that and the information from the tip previously given from the bartender to watch this driver was sufficient, constituted reasonable grounds to sustain the conviction. Another motor vehicle case, but this isn't a driving case, it's a theft case, a St. Patrick's Day vehicle theft case. Car is stolen by some man who then drives this stolen vehicle and crashes into a tree on St. Patrick's Day. He is charged with motor vehicle theft as a result of the crash when the police got to the scene. However, by the time the police got to the scene, the driver was no longer in, he was no longer in the vehicle, and he claimed that a friend of his had been driving the vehicle and was the person who stole the vehicle, and he, the defendant, was only in the passenger seat, not the driver. He didn't steal the car. He was just on a joyride with a buddy of his. And the buddy of his not testified, but told the police officer, verified his story, corroborated his story. The buddy came to the scene and said, yeah, I was driving the car. It wasn't him. Why the buddy said that, don't know. Record's not real clear, but the police didn't believe him anyway and ultimately proceeded with the conviction. The man then appealed the conviction, claiming that he wasn't the driver of the car and hadn't stolen it. By this time, his buddy had recanted and said, you know, maybe I wasn't driving that night. I come to think of it, I guess I wasn't driving. So even though the friend had originally said that he was the driver and had stolen the vehicle, by the time the case goes to trial, the driver recants his testimony, which kind of leaves the passenger, the claimed passenger, the alleged purported passenger, in kind of a bad place. Furthermore, the court pointed out that there were footprints in the snow that indicated that someone had gotten out of the passenger seat, and those footprints matched the shoes that the defendant had been wearing. And there was also dry floor mats on the passenger side of the vehicle, which indicated that the man had not been sitting on the passenger side because it was a snowy night. And to top it off, there was even a witness who said there was only one person in the car, and the witness was somewhat able to identify the defendant. So all of those factors congealed to uphold the conviction of the St. Patrick's Day motor theft case. A couple of robbery rulings, a couple of other criminal actions on St. Patrick's Day. These are two St. Patrick's Day robbery convictions, both upheld by the 8th Circuit. Incidentally, these two cases are upheld. All these other cases are upheld. Are you seeing any theme here? Each of these cases where some wrongdoing was alleged in some kind of, in a criminal context on St. Patrick's Day, in each of the cases, the defendants have lost. I don't know if that's a point of law or not, but it's somewhat notable that wrongdoing on St. Patrick's Day, at least in the criminal context, does not result in exoneration of the defendant. These are two St. Patrick's Day cases. One of them they're both serious. Any robbery is serious, but the first one is a very serious one. U.S. versus Ayton, A-T-T-E-N. It's a federal case, and this was an armed robbery of a bank here in St. Paul on St. Patrick's Day, and a security guard was killed in that robbery. Serious stuff. The government sought and proceeded with a capital conviction under the federal death penalty law as in existence at the time. Death penalty statute has been changed a lot of times, but the one that existed at the time was the basis for the feds seeking a capital conviction of this man for killing a security guard during a St. Patrick's Day bank robbery. The man was convicted and received a capital offense. He appealed that and claimed that one of the statutory factors under the then existing federal capital punishment statute had not been alleged in the indictment. So it's a pleading deficiency that was the predicate, or the basis of the defendant's appeal, that the charge, the indictment, did not reference all of the statutory factors necessary to sustain a capital conviction. And there's a number of them. Again, the criminal lawyers will be more familiar with it than I am, but the federal statute has a number of different factors that have to come into play in order to activate a capital conviction. It's multiple. I think there's like 18 different factors. And the defendant said, well, you didn't say all of those factors, and therefore the indictment is deficient, and therefore the conviction ought to be overturned. The court rejected his argument and said it was harmless error. And articulation that comes up often in criminal in affirmances of criminal convictions. The court recognized that the indictment was deficient. The indictment did not properly cite the language from the federal capital punishment statute. However, the court dismissed that argument by calling it harmless because this defendant, the court said, was clearly guilty anyway. And the court said his guilt was clearly established beyond any reasonable doubt because he had made a remark before going into the bank of his intent to use bullets, intent to kill someone, and he had a large stash of bullets in his car, and he even had explosives in his car, which certainly indicates a depraved mind and premeditation and all of the other factors that warrant a capital conviction, notwithstanding the failure to use the right wording in the indictment. Another bank robbery case that went to the 8th Circuit is not a bank robbery case. Another robbery case is a bar robbery in the wee hours of the morning after St. Patrick's Day. So this is early morning, March 18th, after St. Patrick's Day. The bar is closing, and it gets robbed by an individual. Actually, two individuals came in and robbed the tavern at closing hour in the early wee hours of post St. Patrick's Day. The issue in the case was the identification of the robbers by the barmaid. Remember, we had the other case there where a bartender gave a tip to the police about a DUI. Here's a barmaid woman who identified these two robbers. She didn't know who they were. They were not regular customers there. They weren't in the bar waiting for closing hours. They kind of came in at closing hours. So it was late at night and dark and at the end of St. Patrick's Day, and the barmaid was the only witness who could really identify who these robbers were. And there was no other good corroborating evidence. This isn't the kind of case where the police found the money on the robber's person or in their car or stashed at their home. There was no weapons that they found. The case turned largely, almost exclusively, on the eyewitness identification by the barmaid of these robbers in a fleeting moment, who ran into the bar, robbed her, robbed the cash register, and left. Two of them. And the court upheld that. And they said the eyewitness identification was, quote, reliable and sufficient in and of itself in the absence of any corroborating evidence to sustain the conviction. The defendant had argued that the barmaid really had not had a good view of them, defendants, or two of them, had not had a good view of them, and they pointed out that the police showed pictures of the defendants, the arrested individuals, to the barmaid as part of their interview with her. They showed her these pictures of these individuals, said, are these the two men who robbed the bar? And she relied on those pictures in forming or framing her identification. So the key issue was the quality and legality of that kind of identification process. The court said it was reliable. There was enough, at least in the record, to indicate that the witness was acting reliably in the absence of any other evidence. There's pretty slim evidence, but the court said that's enough. There doesn't have to be corroborating evidence. There doesn't have to be multiple witnesses. There doesn't have to be anything beyond an eyewitness identification if believed by the jury. And the court said there was enough here to sustain the conviction. The issue becomes somewhat more interesting today because of all the concern about eyewitness identification. I know there have been a number of decisions by our courts that have questioned the quality of eyewitness identification. There is I think it was in his last ruling, the decision while he was on the Supreme Court, Justice Paul Anderson, I think it was in a concurrence, really had quite a lengthy and worthwhile discussion of the frailties of eyewitness testimony, particularly interracial eyewitness testimony. And the courts around the country have been really concerned about eyewitness identification and questioned the caliber and quality. And I believe we even have a study going on here in Minnesota about the validity and use of eyewitness testimony in criminal cases, with particular emphasis on interracial identification. This case is kind of an early version of some of the concerns about eyewitness identification and how it can be flawed or tainted, but not flawed or tainted enough in this particular litigation to warrant a reversal. Finally, here is yet another St. Paul criminal St. Patrick's Day case. It's pretty interesting and unusual. This is a case that involved a conviction, a criminal sexual conduct charge against a Hispanic man. Serious case of a Hispanic man who was charged with criminal sexual conduct, in other words, rape. Case was here in St. Paul. The case did not occur on the incident did not occur on St. Patrick's Day, but the trial did, or at least the conclusion of the trial, it concluded on St. Patrick's Day, right downtown here in a Ramsey County courthouse. The prosecutor, at the end of the case, closing argument in this criminal sexual conduct case against a Hispanic man, made some ingratiating comments to the jury in her closing argument. She said, this is on St. Patrick's Day when she's giving her closing argument. She said that she noted that it was St. Patrick's Day, and she commented how the jurors probably were wanting to go out, have some fun and frivolity that evening and enjoy themselves. And she pointed out that she was, quote, a little Irish. And she said, it's a little bit disappointing that only 3 of you jurors are wearing green apparel as I am. And she pointed to her green apparel. So she promoted herself as a St. Patrick's Day woman and tried to appeal to the sensibilities of the jurors in siding with her in an ingratiating way because it was St. Patrick's Day. That formed the basis of the appeal. The defendant claimed prosecutorial misconduct. The defendant claimed that the comments made by the prosecutor, trying to ingratiate herself with the jury, pointing out it was St. Patrick's Day, pointing out she was, quote, a little Irish, and commenting upon the custom and practice of wearing green on St. Patrick's Day, were not relevant, and they were prejudicial, particularly, so the claim was, because this was a Hispanic man. And it raised, at least from the defendant's standpoint, some racial and some inflammatory racial type issues as well. The court rejected that argument. Yet another St. Patrick's Day affirmance of a conviction. The court said the trial as a whole warranted conviction. Basically a harmless error type of analysis, although our Minnesota Court of Appeals did not use the term harmless in this case, but they said looking at the record as a whole, it warranted conviction, despite the remarks that they admonished the prosecutor. They said the prosecutor probably shouldn't have made those remarks because she was seeking to curry favor with the jury, but nevertheless, it did not warrant a reversal because the evidence as a whole warranted a conviction. So yet another example of a conviction of a St. Patrick's Day case. We've seen a number of those criminal cases, and I think that's pretty much the conclusion of my presentation. I don't know if we can take questions here or not, probably not in the webinar, but If you want to submit a question or comment or observation by email, in the chat room, by chat, I'll be glad to answer them. But otherwise, have a happy St. Patrick's Day and enjoy the rest of the day as much as you can under the circumstances. Yes, we have a question here from our vast audience here. Talk about social distancing here. I guess the latest guideline is to limit, at least the federal level is limit to 10 or less, I think. Well, we're well within that, I can assure you. Liz, Becky. Yes. Oh, yes. Be happy to. Yeah, oh yeah, I'm able to do that. Yeah. Pardon me for not knowing their names off the top of my head, but there are 3 cases that were consolidated. They were argued on the second day of the Supreme Court term back in October. First Monday of October. This was the first Tuesday in October. So the Supreme Court have heard 3 consolidated cases that all raise, the contexts are a little bit different, but they're all employment cases. They're all from different federal circuits, and there's a split in the circuits. One of the cases came out favorable for the claimant. 2 of the cases came out favorable for the employer. So there's a split in the circuit. What's the split about? Whether the Federal Civil Rights Act, Title VII, the discrimination law, the federal discrimination law applies to gays, lesbians, transgender people. The statute does not, by its terms, say so. For years, there have been attempts to amend the federal discrimination law, Title VII, to include discrimination based on affectional preference, covering gays, lesbians, transsexuals, queers, and anyone else who has an affectional type preference or a gender identification type of issue. The measure has been brought up, I think, every year since 1992. It goes back to Senator Ted Kennedy first brought up. It's called EDNA, and I think the name has changed now, End Discrimination Now Act, but it has never gotten a favorable vote in Congress. I believe this year or last year, I think the House of Representatives did finally approve it. The federal U.S. House of Representatives did approve that law, but it got nowhere in the Senate, and it's one of those many pieces of legislation that's sitting on someone's desk in the Senate. And as the composition of the Congress exists now, and the status of the present administration, I don't think we're likely to see an amendment to the statute. So if any change is going to be made, it probably is going to have to be made by judicial interpretation. The argument made in favor of applying the Title VII to the LGBT community is that essentially it's a form of discrimination based on sex. And the statute, Title VII, does not it says discrimination is illegal based on sex. The argument made by the claimants in these cases, these are 3 employment cases. One was a worker in a mortuary home who was fired. I think it's a man, maybe it's a woman, I don't know. But upon disclosure, the claimant disclosed sexual preference and got fired. Another one was a parachute jumper who assists people and trains people to do parachute jumping. And that person identified as gay and was fired. So, well, we don't want you, touching and in contact with the parachute people, the people you're jumping out of parachutes with, and you kind of go together and you're in physical contact with them. I forgot what the third one was, but in each of those cases, the employers took adverse action against employees because of their affectional preference. That's not disputed in those cases, at least at this stage of the cases. None of them has gone to trial. They're all in the motion stage. In 2 of the cases, the federal circuit courts held that the claims are not maintainable under federal law because federal law does not explicitly state that it covers affectional preference, as many state laws do, including Minnesota. And that's the one of the cases did hold that the law does apply. So that's the split in the circuit that got up to the Supreme Court. 3 cases, all consolidated. Don't remember the names. So the argument made by the claimants in those cases, this is discrimination on account or based on sex. Therefore, it falls within Title VII. The argument made by the employers is no. The statute is silent. It doesn't say anything about affectional preference. They point to the many state laws that specifically carve out affectional preference. And the employers argue if Congress intended to extend the Title VII to affectional preference, it could have did so back then. And they point, the employers also point to the long history, more than 25 years, in which Congress has tried to legislate. And the defendants say, you see, that proves that the statute doesn't cover affectional preference because the Congress itself is trying to enact that measure, and the courts should not engage in legislation here. A court should just interpret the law as it is, and the law is silent. It's a high-profile case. It was, as I said, argued high-profile 3 cases. Litigation was argued early in October, and as they say, a decision is expected before this court adjourns in June. If we get any more decisions from the court, that's a whole different issue. A number of observers, now, at first blush, one would think, well, this is kind of one of those values issues that maybe will be decided on conservative liberal lines. We may be headed to a 5-4 decision here, maybe one way or the other, depending upon which way particular judges go. But at the oral argument, Justice Gorsuch surprised some people. And again, as many people know from who are involved in the court system, the questions from the judges aren't always dispositive, and you can't draw too much from it. I was in court yesterday, one of the rare remaining court that is still open, and it was a hearing, and the judge at the beginning of the hearing said, I'm going to probably be asking some questions, and he told both sides, don't necessarily construe what I'm saying as what way I'm leaning or not. And they said, sure, that's right, Judge, but we know that that's not always the case. So judges' questions oftentimes are pretty illustrative of which way they're leaning, but not always at the Supreme Court. We know they ask a lot of, questions, just hypothetical questions and trying to frame their thoughts. But Justice Gorsuch made the comment, and we also at the Supreme Court level, oftentimes there aren't so much questions as the judges kind of make speeches or make remarks on how they feel about something. Gorsuch did say at the argument that he asked the attorney for one of the defendants, the employers, how can you say that this is not based on sex? He said, it seems to me that any kind of the actions taken here by the employer are on the basis of sex, and therefore it would seem to me that it would fall within Title VII. Huh? And so he framed it as a question, but in other words, the observers there and the media people said, oh, that suggests that Gorsuch is leaning one way or the other, and maybe he is, maybe he's not. There was no significant, I don't think there was any significant other leanings that were surprising, although Justice Roberts asked questions at the oral argument, Chief Justice Roberts asked questions at the oral argument that kind of leaned both ways. Some of the advocates for the claimants were heartened by one of the questions or comments Roberts made, and I forgot which one it was, but another one of his comments was more heartening to the employers. So it's going to be a close call probably, and I think it'll probably go 5-4 one way or the other. And it's going to have a significant impact, obviously, on the rights of the LGBT community, not just at the federal level, but even at the state level. Many states, I forgot the last count, but about half, I think it's 22 states have, like Minnesota, have affectional preference statutes, but many don't. And the Supreme Court decision could be an influential factor in getting some states to jump on board, or perhaps getting states to not move forward, and perhaps even to lead to possible repeal of some statutes in certain states. So I think it'll be a harbinger of where LGBT rights go in the immediate future. Oh, did that answer your question?
Yeah.
Okay, I'm sorry I don't remember the names of the cases, but Yes, I'm glad you asked that, Lee. Probably, I'm not going to go into his background here. I think he was a local prosecutor but basically in private practice as well. I think he was from Greater Minnesota, but maybe it was St. Paul. But anyway, he's a Minnesota lawyer and been for many years and had a good, solid private practice. He was appointed to the Supreme Court. This is Pierce Butler, for whom I think there's an avenue name somewhere here in St. Paul. Pierce Butler, he was named to the Supreme Court, I think, in the 20s. He was a Republican appointee. It may have been Harding in his tenure. It may have been Coolidge. It may have been Hoover. Not sure. I think it was Herbert Hoover appointed him, but I'm not sure. But he was a Republican appointee, and he was a Republican. I know you shed that label when you go in the Supreme Court, right? But he was a Republican appointee, and he was a member of the Gang of Four back then, the quote, four old men, unquote. And he was a staunch conservative, and there were three other staunch conservatives, and they got in the way of a lot of the New Deal legislation, oftentimes getting one more convert. There were four of them that were called the Gang of Four. They were, as I said, staunch conservatives. They voted against most of the New Deal measures as being unconstitutional. Social Security Act, and not Social Security, but a number of the New Deal measures, the NRA, WPA, a number of the Social Security measures, they opposed them. They opposed them and ruled a number of them are unconstitutional. And oftentimes they got another stray member of the court. So they were a big roadblock to the New Deal programs, and Pierce Butler was one of those four or five, okay? And they were called the old men on the court. That led to Roosevelt's court packing proposal. Most of you are familiar with that. After he was reelected in 1936, shortly after he was reelected, within months, Roosevelt's second term began with him coming up with a court packing proposal. And it was born out of Roosevelt's frustration, FDR's frustration, that so many of his laws had been deemed unconstitutional, important laws in the New Deal era. And they were not, by Pierce Butler and his cohorts. So what Roosevelt proposed as in the court packing proposal is that each time a judge turns 70, that the president could appoint a new judge up to a total of 15. And that went over very badly. The public, by and large, viewed it as being a usurpation of power by the president, and there was a break from tradition. Although traditionally, as many people know, we didn't always have 9 judges on the Supreme Court. There were periods of time when there were 7 judges on the Supreme Court. The first Supreme Court only had 5 judges. So 9 is not a sacred number for the Supreme Court judges, but the Roosevelt's court packing proposal went over like a dud, and it was his first major defeat in the public arena. And he had, at least at the legislative level, he had had obviously great success in his first term with legislation. It didn't always stand up in court, but this really, the public was soured on this by and large, and it died, never even reached a vote in Congress, and it was a major defeat for Roosevelt. The court packing proposal. However, it wasn't necessarily a defeat in the long run, because those 4 or 5 justices started to come around and upheld most of the New Deal legislation in the second Roosevelt term, and that included the Social Security law, it included the National Labor Relations Act, and a number of the laws that we are part of our daily lives were challenged during Roosevelt's second term. And the 4 staunch judges still opposed them, but nobody else joined them, and Roosevelt got by with a number of 5-4 decisions upholding most of his New Deal measures. And it was said that his court packing proposal at least sobered up some on the Supreme Court and kept any of the other judges from joining the 4 that were aligned with Butler. And that's what happened. Now the court packing issue is back in the public arena a little bit. Pete Buttigieg, Mayor Buttigieg, Mayor Pete, had proposed a somewhat of a revision plan, and to add and change the composition of the Supreme Court. Some of the other Democratic candidates have raised that issue. It's certainly retreated to the background now, but during the primary season a couple months ago, changing the selection process and composition of the Supreme Court was an issue. It harkens back to the court packing of Roosevelt, which involved Pierce Butler, and so what goes around comes around. But Butler's probably most significant role that comes up in the judicial lore is his role in the Neer versus Minnesota case. Neer versus Minnesota, as most of you know, was a case that arose out of Minneapolis, Hennepin County. The state had a nuisance law that allowed county prosecutors to close down essentially offensive newspapers of the day. There were a number of so-called scandal sheets that were virulently racist, anti-Semitic, but also rabble-rousers against corruption in City Hall, and they were called scandal sheets or rags. And they had a gamut of data for just about anybody. If you're a racist, you could read about racial issues in these papers. If you're an anti-Semite, you had your fill of anti-Semitism. But you also had some good government people who are supporters of these newspapers because they really hit hard on corruption in city government and law enforcement. This Hennepin County prosecutor used the state nuisance law to shut down one of these newspapers. That prosecutor's name was Floyd B. Olson, who later became governor of Minnesota. That case went all the way up to the Supreme Court in Neer versus Minnesota. And as most of us know from our law school training, that is the quintessential prior restraint case decided by the United States Supreme Court. The issue was, can a state suppress a publication because it is offensive and a rabble-rouser and contrary to the good morals of the community? That was the statutory language. And the Supreme Court heard that case in 1931 and decided by a 5-4 vote that the First Amendment bars prior restraint. Up until that decision, the Supreme Court had never applied the First Amendment, or for that matter, any of the Bill of Rights to the states. That was the first time that the Supreme Court ever held that any of the Bill of Rights, including the First Amendment, applies to the states. That was a signature decision, a signature result of that case, along with the doctrine against prior restraint by a 5-4 margin. The court said, with some exceptions, in times of crisis or in times of war, there may be some exceptions, but ordinarily, government cannot prevent, censor, suppress someone from saying something that's not illegal in and of itself. That was a 5-4 decision written by Justice Charles Evans Hughes. One of the dissenters, the 4 old men, dissented, and had one more person join them, the ruling would have been, you can have prior restraint, you can censor newspapers, you can close down publications that a particular administration thinks is unfriendly or even unpopular. Pierce Butler was one of the 4 dissenters. Had they attracted one more person, it would have been a 5-4 decision, and the course of America and jurisprudence may have been changed in a major way, both in terms of the application of the Bill of Rights to the states, as well as the substantive doctrine under the First Amendment. So that's my short biography of Pierce Butler. I hope that answers your question, Lee. It probably told you more than you wanted to know, and you probably know more than I know about it anyway. Well, thank you very much. I see my time's up, so this has been my pleasure. I hope I've brought a little bit of information, enjoyment, entertainment, and interest on litigation concerning St. Patrick's Day. And perhaps next year we'll all join together for a reprise of this presentation, all in the same room at the same time. Thank you very much.